Minnesota takes habitability seriously, and the state has built a comprehensive legal framework that landlords need to understand thoroughly. Minnesota's primary landlord-tenant law is found in Minnesota Statutes Chapter 504B, and it creates clear obligations that apply to every residential rental in the state. Under Minnesota law, landlords have a statutory duty to keep the premises in reasonable repair. You must maintain the property in compliance with all applicable health and safety codes. Keep the structure weathertight and in good condition. Ensure plumbing systems work properly with hot and cold running water. Maintain safe electrical systems. Provide heating capable of maintaining at least 68 degrees Fahrenheit, which is absolutely essential given Minnesota's legendary winters. Keep the property free from infestations. Maintain working smoke detectors and carbon monoxide alarms, and keep common areas safe, clean, and properly lit. Minnesota also has a specific statute that addresses covenants of habitability, Section 504B.161. This provision makes it clear that in every residential lease, there is an implied covenant that the landlord will keep the property fit for its intended use. And here's the important part. This covenant cannot be waived. Any lease provision that attempts to shift basic habitability obligations to the tenant is void and unenforceable. What sets Minnesota apart from many other states is the strength of its tenant remedy process. Minnesota gives tenants access to what's called a tenant remedies action under Section 504B.395. This is a special court proceeding designed specifically for habitability complaints. Through this process, a tenant can ask the court to order the landlord to make repairs, reduce the rent to reflect diminished habitability, allow the tenant to make repairs and deduct the cost, appoint an administrator to manage the property if the landlord is persistently non-compliant, or even order the landlord to pay the tenant's court costs and attorney's fees. That tenant remedies action is a powerful tool that you don't see in most states. It gives tenants a direct path to court-ordered relief without having to navigate a traditional breach of contract lawsuit. Minnesota also allows rent escrow. Under Section 504B.385, tenants can deposit rent with the court if the landlord fails to maintain the property. The court holds the funds and can release them to the landlord once repairs are made, or order them returned to the tenant if the landlord fails to comply. This process requires the tenant to be current on rent and to have given proper notice, so it has built-in safeguards against abuse. Minneapolis and St. Paul each have their own additional housing codes and inspection programs. Minneapolis requires rental licenses and conducts regular inspections through its Regulatory Services Department. St. Paul has a similar licensing and inspection system through its Department of Safety and Inspections. Landlords in the Twin Cities metro area are essentially operating under 3 layers of regulation: federal, state, and local. So compliance requires attention to all 3. Minnesota's cold climate makes heating a critical habitability issue. Courts treat heating failures during winter months as emergencies, and landlords are expected to respond immediately. A furnace that goes out in a Minnesota January is not a 14-day repair situation. It's an urgent, same-day issue. The state's anti-retaliation protections are strong. Under Section 504B.441, landlords cannot penalize a tenant for making a good-faith report to a government authority about a code violation, complaining to the landlord about habitability issues, or exercising any right under the tenant remedies statute. The presumption of retaliation applies for 90 days after the tenant's protected action. For the complete guide to Minnesota's habitability requirements, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel so you don't miss a single state in our series.